Pag sinabi kasing complete, ibig sabihin po ay.
All right, hello, good morning, everyone. Hi, good morning. So I know you are all students from the ES 19, no, Technopreneurship 101. So welcome to this webinar about the basics of intellectual property. All right, so it's already 10:32, so there are still participants coming in, so we'll just accept them as we proceed with our talk, because we have quite a few or plenty of things to discuss now. So yeah, so we'll proceed with this. Prior to this, I have actually a class now on ES 19, also Technopreneurship 101. So we're talking about business models, how to run your startup. And intellectual property is one of the very important aspects of a startup or a technology-based startup. So we're gonna discuss about some of the things. I know we have a very limited time. We have 1.5 hours, and I'll try to compress everything into 1.5 hours and try to skip some of the things that I think we may not need discussing anymore, no? Because we usually give this webinar for around 4 hours in a day, so we just try to compress everything. So let me share my screen now. I hope everyone is in good health. No, we know we have a very, very high cases of COVID-19 here in Butuan now. All right, to start off, so I may pause somewhere along the way because I have to accept other participants. So I get distracted sometimes. All right, to start off, I would like to introduce myself. No? So I am Jeffrey Deliosa. So I am the director of the Technology Transfer and Licensing Office in the university. So I think you don't see me in the college even before the pandemic, because I'm on a separate office. And then, but I am a professor of the electronics engineering department. So we started also, me, Roland Dagil, and we started the Navigato, the Technology Business Incubator in Caraga State University. And I'm also leading the entrepreneurship program in the university right now. So with the help of the guys in CCIS, Melbert Bonotan. And we are trying really to change mindsets in terms of entrepreneurship and part of our job is to educate, as many as possible. So actually, we kind of organized that in June there will be a pitching event, for the top 5 groups, among your class. All right. So I will not expound myself a lot more, because I mentioned we have very limited time. But you can look my profile in Google Map, or in Google, or in LinkedIn. So I'll put about me. So the details about my profession. All right. So let me start. So I hope you're all in good mood. Still not hungry. So we can finish this by 12. So I hope you learn also something new today. So I'm open to a questions. You can chat your questions in the chat box, or you can open your mic and call my attention in between the slides, and feel free not to ask questions. I know you guys may have some questions or clarifications, so don't hesitate to call my attention, right? Right, so let's proceed. So fundamentals of intellectual property. Okay, so there are more people getting into the webinar. So let's go to the first slide. So have you heard about patent wars? No, so patent is a form of intellectual property that we're gonna define later on, but this is something that is happening, going on in the global stage. Now, it's not only in the Philippines, but actually primarily in big markets. So when we talk about big markets, that could be the US market, the European market, or in China, Korea, Japan. So these are the economic powers in the world. So, and there are ongoing patent wars by the different companies. So one major electronic company fighting other companies about intellectual property rights or patent. So they're thinking about, I have an intellectual property of my product or services, and some other guys or some other companies like try to copy and cause infringement of the products originally created by another company. And when somebody copied it, of course, the original creators would like raise their eyebrows, and then they would kind of look into the legalities now if they can go sue or go to trials in terms of claiming ownership of the patent. So these are some of the things going on right now, in the world. And I think you've heard before that Apple and Samsung actually, they're fighting over ownership, in terms of the technologies that they develop. I think for smartphones, it's safe to say that I think Apple really revolutionized the mobile phones, or the smartphones. So they introduced this in 2007, and then that's the time that Samsung as well tried to develop a similar mobile phone technology, because we know for a fact that Nokia, the telephone company that existed prior to Apple and Samsung in the smartphone business, so they were the leading company. So in terms of innovation, Nokia really captured the entire market in mobile phones in, I think, late 1999. So in late 1999, I don't know, guys, if you were born already in this year, but 98, 99, that's where the mobile phone market started to grow. So Nokia was the leading provider, but the problem with Nokia, they were not able to innovate their products. And then, yeah. So I have to mute other participants. Requesting all to mute your mic. So, all right. So, of course, Apple introduced the smartphone, and from that time, they were able to get the entire market share. And then Samsung also developed their own mobile phones. And then we know the story that Nokia is out of the picture, and then Apple really control the market. But we know for a fact that today we have different players other than Apple and Samsung. Like you have Huawei, you have Vivo, Oppo, what else? Banana, no, Oppo. So, yeah. So Well, the thing is that Apple and Samsung are fighting over the. Apple claimed that Samsung copied the technology of Apple, no, and even the design. So that's why Apple said, "I will sue you. I will go to the court." No, in the U.S. courts, Apple filed for patent infringement, and the result of this is that actually they did not reach really the trial, no, but they kind of work into the settlement. So they did not reach the trial, but they were able to settle out of court, and Samsung was ordered to pay Apple for $539 million. That's a lot, no? If in terms of pesos, Pilipinas 25 billion pesos, no? For the reason that Samsung infringed on its patents. So in terms of the intellectual property related to patent, the court or these two agreed that okay, so we will settle this out of court, and then Samsung paid Apple for this. So it's been a long time, no? So that's why you'll never see similar design now of the Apple phone with the Samsung phone or any other companies. So just okay. So you cannot find any more similar technology or design, no, with Apple. So even before that, actually, the reason why Galaxy was able or Samsung was able to copy Apple because of the fact that Samsung actually developed the processors for Apple. So that's what the technology was all about before. And yeah, Nokia also escalates their own patent wars by taking German Lenovo. No, so we know for a fact that Nokia tried to come back, no, and then they were able to actually develop a product, but it's not as appealing as what we have now with Apple, Samsung. So the market leader is Apple and Samsung, right? So this is on the backdrop, no, that they're really fighting over. In terms of 5G, so I'm not sure if you're ECE student, but if you're not, so we know you're familiar with the technology that we have advanced towards the 5G, no? So faster internet connection, lower latency, and yeah, so there is also an ongoing patent war in terms of this technology. And patent is, this is the question that we also have to answer, you know, and understand why patent is very important for companies in the knowledge economy today. You know, so before it's driven by assets, no, that is not assets that you can find or you can see, you know, like the lands, buildings, people, of course. You know, so for companies, you know, so for major companies, intellectual property is very important, and because you have this like properties that you may not be able to see or hold, but then the value of that is actually enormous. So the way the settlement, out of court settlement with Samsung to Apple, that's a huge amount of money, no, and that's IP. Now, so if you look at that, so parang you would then ask yourself, Samsung was willing to pay for 532 million for what? No, so they did not even like get a building. No, they did not even get a piece of land for Apple. They did not do it. No, so they're paying 500 million US dollars. No, so as if like they stole, no, they stole a land, a building out of Samsung, and yet they were forced to pay 500 million US dollars to Apple. So these intangible assets, this from the knowledge economy, really important because of the value that it provides to the company. No? So in today's knowledge economy, so I think you've heard about this before, that knowledge is much more important right now. No, it's your know-how, the skills, no, the technical skills that you have, your human creativity and innovation. So there is infinite or limitless parang opportunity for you in terms of developing products or services, innovative products or services, in terms of creating value for your customers, shareholders, and stakeholders. You're referring to the company right now. So We go out from our classroom, no? So we're talking about what is happening in the world, no? So this is it. So the knowledge economy. So it's no longer just about land or something, no? It's about you as individual. What do you put on the table? Kumbaga, no? So when you are hired in the company, so imagine yourself, no? You will be looking for a job, no? So the company will really consider how much skills do you have, that the company will take advantage of. What is your value that to the company that they will hire you? Okay, I hope that's kind of parang analogy, no? So of course they need people, no? The companies need people, and they would think about why would you be the person who will be hired rather than other people. So in terms of skill set, knowledge, so that's why those cum laudes can find immediately their job, no? Because they demonstrated that they have the knowledge, they have the know-how sometimes. So they know or the human creativity and innovation. So that's when companies value the sets of skills that you have or the knowledge, because we are now living towards the knowledge economy. The value that you can offer, it's not about your providing investment to the company, no, but rather the knowledge that you will be able to help the company solve their problems and so on and so forth. Okay, so this is becoming important. That's why in today's economy, knowledge is very important. Skills. Okay, so it's no longer about low cost, so creating value. No? So I think in your Tech 101, we talk about the business model. No? It's about what value proposition you can provide to the customers. So it's no longer just about the cost. No, it's about offering products or services that is faster, cheaper, better. No? So terminologies like this, no? In the business model canvas, I'm saying this to our T101 students, the value proposition is the most important aspect of the business model. Now, what kind of value are we offering to our consumers? Now, so I mentioned this, that if you're gonna offer, if you're a startup, you're starting your own company, and there is already a competition, the same product in the market, same players in the market, like that of, for example, the food delivery services, there is Grab Food and there is already Food Panda. And now you are trying to introduce your own startup that is also food delivery. Now, there is a competition right there. A question is, what is the value that you are trying to offer differently, other than the Grab Food and the Food Panda, the value proposition you're offering? Do you have a unique selling proposition you're offering? It's no longer about lower cost, because if you introduce a cost, then this Grab Food and the Food Panda will just lower their cost, and then they will already meet the competition that you're, or the value proposition you are offering, right? So it's no longer about lower cost, no? So it's not about the cost anymore. Okay, it's about giving your customers added value, no, a differentiation from what you have. So different from your competition. For example, I told my class before also that you have this Globe Telecoms and Smart, now that are existing in the telco industry. So what kind of value you are offering now as a third telco player? We know that like Dito Telecommunity is already in, no? So what are their value? No? So they're offering 5G technology that provides you faster internet connection, and they would offer you better products or services. So that's where Dito Telecommunity is really trying to provide the value, because they know that it's difficult for them to compete if they're just similar to Smart Telecoms and Globe Telecoms. All right. Okay, so when we talk about the new economy, creating value, now, so we are referring to more or less to the intangible assets. So these are the biggest value drivers in today's economy. And what are they? Now, so unsa man yung mga intangible assets? I think before going to this slide, the intangible assets are those assets that you cannot actually like see, no, your very own eyes. Now, so intellectual properties among them. Now, so the difference between intangible and tangible, the tangible assets that companies boast before, in several decades ago. If you're a company that has plenty of lands, plenty of buildings, then you would consider that you're the biggest company, but not anymore in today's knowledge economy. Intellectual property plays a part of that, and I will try to tell you why. So, for example, here in this slide, in 1970s, going towards 2015, there's a shift between companies in terms of the tangible assets that they have and the intangible assets. In 1975, in this graph, you have more intangible assets, meaning to say companies have more lands, buildings, and so on and so forth. And then vehicles, all the hard materials that you can find. And then they have very small intangible assets. And looking at this 2015 graph, it's now different. Now, companies have a lot more of intangible assets compared to their tangible assets. Okay, this is one of the examples. Why is this so? In 1995, I think you were not born yet. So Netscape, this is one of the internet company before. So yeah, they were just worth 17 million US dollars. So with very small number of employees. But they're very high-tech, they're very knowledgeable employees. They have very, very good people who can develop internet products. And they tried to list in the company, though. For example, you've heard about the New York Stock Exchange. So they tried to list their companies in the stock exchange. And when you offer that in the company, so investors would question themselves, is this company worth buying? So when they've heard about Netscape, going into public in the stock exchange, the investors really purchase a lot of stocks, and then immediately then the Netscape was valued at 3 billion US dollars. So during the first trading day, so if you're familiar with the Philippine Stock Exchange, so more or less just the same. So that's what we call the IPO, or the initial public offering. So what were investors buying? So certainly not the 50 telephones and the company's inventory of software. So it's not just about that. It was just about the people who had built Netscape because of their knowledge, skills, ideas, and talents, who will be able to innovate continuously. So that's where that's why one of the major reasons why a lot of investors bought Netscape, the stocks of Netscape. So they believe on the company. So we can relate as well to Tesla right now. So they believe on Elon Musk, a lot of followers. So you'll see Tesla as a car company. For those who are not familiar with Tesla, so today, Tesla is a car company that is actually battery operated cars, but they develop cool cars, right? So people invest in Tesla because they believe that Tesla has a very good engineers, has very good CEO, talented, very intelligent, smart. So that's why. It's one of the reasons why investors love Tesla. Okay, next. So I've mentioned about this, Tesla, and in terms of market capitalization right now, it's worth 103 billion US dollars. And these two other US companies, General Motors and Ford, although they produced a lot of cars, look at the graph. They mentioned 2 million cars produced in 2019 for GM, and then 2 million cars also for Ford in 2019, despite the fact that Tesla has just been able to produce 190,000 cars, they remain as a higher valued car company because they have technology, they have technology and they have people, and then investors in the stock market value even more compared to the traditional car companies. Okay, so that's the challenge for Tesla, for these other companies. Okay, so what can you say about Tesla? I'm not sure if you were able to follow the story of Tesla. Right now, it's not even 103 billion US dollars. They've grown their company to bigger than this. So yeah, so there's another feature of Tesla. So investors always flock to Tesla, and their stock is even much higher, compared to these existing competitors. Today they're even bigger than Toyota, Honda combined, no? Because they're becoming big company. They have bigger factories. So that's how in the knowledge company, because in the knowledge economy, investors value intangible assets. Okay? So di na ako na storyan, no? But in the knowledge economy, I have to mention that part of the intangible assets are those patented technology, computer software, and mass words, even including the the unpatented technology. All right. So these are the things that are included in the intangible assets. Okay. Just hold on. I'm trying to yeah, there's some problems with my settings here. The settings is not responding. All right. So continuing on. Intellectual capital, if you look at the knowledge economy, so intellectual property actually belongs to the intellectual capital. So there are two kinds of capital, that is financial capital, and then you also have the intellectual capital. Okay, so intellectual property belongs to the intellectual capital. All right, so what is intellectual property? Now the definition for IP. So refers to the creations of the mind, inventions, literary, artistic works, symbols, names, images, and designs that are used in commerce. So if you have an idea, so it's not just an IP yet, no? So because it's just simply an idea. So you have to transform this idea of yours that to become a creation, no? So it's a product or process or service. So you have to make sure that your idea are expressed. Now, for example, included here are making books, no? So if you have literary, artistic works, even your letters or your poems kind of belong to the literary, no? So invention. So we'll discuss this in detail. So if you have an intellectual property definition, intellectual property right gives the owner the right to exclude others from commercial exploitation of the intellectual property. So no other person can actually produce or make use, no, of the intellectual property if you are provided with an IP. So that's the thing. So you have to make sure that you have an IP, then you will be provided with an IP right by the state, and then you will have, as an owner of an IP right, you'll have the right to exclude others from selling, producing the same product that you have, no, in the market. So meaning to say, if you have a patented or an IP of your product, then nobody else should be in the market. So if you can find a similar product that is copied from your patented product or protected product, then you have the right not to call the attention of the law, like the police or the NBI or other government institutions, to stop them from selling the same product that you have. So that's the IP right. Now, the IP system, it relates to rights and obligations as well as privileges and incentives, all rooted from the creation and protection of IP. So that means that it's just to strengthen the discussion we have earlier, that the IP system we have in the Philippines would provide you, the privileges and incentives and all the benefits therefrom in terms of the products that you have created. So the state will provide you kind of security, not to really protect your innovations, your inventions, and protect you to be the person, the sole person, not to enjoy your products and services in the market. So what kind of intellectual property assets do we have? So if you have a very innovative products or services, so that means you should apply for patent or utility models. So if you have a very unique innovative products or processes, so go for patents or utility models. So if you have a cultural, artistic, and literary works, then you go for copyright protection, okay? So if you have goods that have certain quality or reputation due to where it comes from, that you apply for geographical indications. So I think the example that we can give you in this is like, for example, manga, no? Manga. So where can you find a very sweet, the best quality na mango here in the Philippines? I think it's safe to say immediately that is in Guimaras. No, you can say Davao, but primarily in the Philippines, we acknowledge Guimaras as the best kind of mangoes. Now, so that means to say that that is when you say mango, then the geographical indication provides you an idea that comes from Guimaras. Now, if you have creative design, so that you have to make sure that you apply for design rights. No, so if you have, I think we're gonna discuss this as well. No? So creative designs later on, and if you have distinctive designs, so you apply for trademark, right? So if you have confidential business information, you have trade secrets. Okay. So these are the different kinds of intellectual property. So depending on what kind of product do you have. So if these are the products that you produce, then these are the different kinds of IP protection that you're gonna get or apply first before really doing business. Okay. If you have a business now, then try to apply for any protection so that nobody else should produce the same copy. Now, for example, you have a book like the J.K. Rowling books, Harry Potter. So nobody else should kind of have the same book as J.K. Rowling. No? So J.K. Rowling is a author. No? So her book belongs to the copyright and related rights category. So there is a copyright protection to that, and nobody is allowed to reproduce it without any proper approval or consent from the authors and the publishers, right? So it's very important. Usually for us engineering, we tend to be under the patents or copyrights. No? So that is where, when you have a startup already, so you have your own logo. So as a startup, you will consider trademark, okay? So if you have a design, very unique design with your product, so you might want also to cover that under design rights. So these are the different forms of intellectual property protection that you have to go, or apply, to make sure that nobody else is copying your product in the market. So because the government will really help you control the market now if you have your own IP. So I hope this is clear. All right. So we proceed with some specific discussions. So the intellectual property is also categorized into two major areas, copyright and industrial property. So most of my talk this morning will be specific to the industrial property. So kind of focus on that because as engineers, as engineering, so we kind of develop patentable products. So but you're into writing, so listening to music, creating works related to copyright. So the protection is really under copyright. So we'll not discuss a lot about this because we have very limited time. But copyright exists immediately after the work, after the work is being established. Now, for example, naghimo ka og letter. After you complete your letter and you send it via email, that means that you have already a copyright protection for that. And then if your work is original, if the work is original, so meaning to say for you to get a protection, that means you need to have original work in everything. You're not, so but copy paste lang sa Wikipedia then doesn't follow. So it will not be credited, it will not be approved, even if you apply. Okay. I hope that's clear. For copyright, that means that so there are more coming in, so I have to admit them. So for copyright, you have literary works, films, musical works, drawings, and paintings. So if you have a drawing, you have a painting, they're protected under copyright. Okay, so all of them, and even the letters they make, so drawings, even the drawings that you draw in the book and then or in your notebook, so they're protected under copyright. All right. So for intangible or for the industrial property, we will discuss them one by one. No? So before that, why IP protection is important? Again, the most basic reasons are to allow the creator or the inventor to really benefit from its invention, because you know the inventor creator spends a lot of time thinking about solutions to a specific problem, and then he was able to develop a product that he sees it as a very inventive. And if it's being copied, then yeah, it's very discouraging for creator, no? And then they will end up not anymore producing it. No? So also to foster return on the investment, no? Because they spend a lot of money, the creators. No? So for example, you might be wondering why pharmaceutical companies, their products are very expensive, because they spend a lot of money in R&D. No? So they spend a lot of money in R&D. So the costs there are high, so that's why their products are also very high. So that's what they follow. So they need to really find ROI, no return of their investment, because they spend a lot of money. The pharmaceutical companies paid a lot of money to the researchers, to the guys working on the products. No? So right now, vaccines. No? So if you're familiar with the vaccines, the Pfizer, the Moderna, these are two brands, biggest brands in the US, developing the products. No? So for COVID-19, and then you've heard about AstraZeneca based in London, UK. No? So they are original creators, and then we have local pharmaceutical companies here called Unilab. It's like Unilab yan. So Unilab yan. So they tried to, actually they're not into R&D, but they tried to copy those So when the patent is already over. But when it's yet still protected, so the company cannot copy those drugs. So what is an invention? So invention is a technical solution to a specific problem. It can either be a product or a process. So there are two things here. It should be a technical solution to a specific problem. That's the primary requirement. So you need to really provide or identify the problem that you are trying to solve. And then product or process. Okay, you have two things here. So for product inventions, you have machines, chemical substances, electronic components, and even including the microorganisms, plants, and animals that have been made or modified. So these are some of the things that you need to think about. So if you develop machines, chemical substances, so formulations, so that's included in chemical. So these are the form of inventive products. So that's why you'll see labels that says patent application pending, for example, or they declare the patent number there. So they are very particular with the patent. Okay. So next is okay, some examples of product inventions. You know that the telephone is invented by Alexander Graham Bell, and then these guys also invented the transistors that we have today that we are being used. And you know the inventors of Apple, right? So Apple were invented. So it's kind of revolutionary, these products that we have right now. And you know that these products were also like protected with patent. So these are inventions. And we know we have this very cool car here. That's a battery operated car, the one I mentioned about Tesla. So doesn't have any engines at all. This front and back doesn't have any engines. So these can be used for baggage or whatever you can put there. So the battery is the battery is actually down below, so in the flooring. So very high tech car. So they really made it very sexy and cool, and people love it in the US, and even you can find this Tesla car in Hong Kong, in Singapore, major cities in China. So they're going towards this adoption of the battery operated cars. Okay, so these two guys really revolutionized the products that we have today in Apple, and especially Steve Wozniak, who started it all. And he was the same guy that actually the PC that we mentioned earlier. So he's the guy, and so is Steve Jobs. Yeah, so he's really introduced the revolutionary products that we have right now, smartphones and so on and so forth. So for process inventions, physical or chemical methods of manufacture, transformation, measurement, control, or other useful in production. So very good example here, nata de coco. Do you know that we are the original inventors of nata de coco, our very own Filipinos? And very unfortunately, the guys from Japan and China went to the Philippines, I think a decade or more, a long time ago, and they were interested because we were kind of exporting this product to Japan and China, and they really love this product. They like this product, the nata de coco. They love this, and so they were really interested about how did nata de coco was produced. No, so the Filipinos are not really familiar about intellectual property, so they just openly discuss about it. So there was no kind of protection. So they just shared the information to these guys who were visiting them. This is a true story. And then those guys who came here really followed to the procedures, on how to produce the nata de coco. And then they went back home, and then, well, what happened is that they produced their own nata de coco. They just simply copied it. And because we don't have an IP protection with that, so they're free to really mass produce it. And the sad thing to say is that we should have been able to really control the market in terms of the products of nata de coco. So sad to say that we are not able to kind of maximize our potential, because not a lot of people were aware about protecting their intellectual property. So they were able to develop a process to produce a nata de coco, and yet that's what happened. So it's sad to say. That's why part of our job is to educate, you guys and even the public. That's why we also have education to MSMEs, the micro, small, medium enterprises in terms of intellectual property. So how do we protect our inventions? So if you have inventions, how do you protect them? Okay, so that's a question. Right, if your invention can be reverse engineered, if the answer is yes, then you apply for patent protection. If not, then you would like to consider it a trade secret. So we will discuss here about trade secret now compared to patent, because I'm not detailing it later. So these are companies that they actually chose to or decided to keep the formulations, the product in trade secret, because they know that it's difficult for other people to reverse engineer it. So what do you think, what product do you think right now that is out in the market for a long time that they remain their products are trade secret? Do you have an idea? Do you have an idea? So feel free to drop down your answers now in the chat box. So what products are they in the market that is being kept as a trade secret because they don't want to share it to the public? What is their formulation? Yes? Yes? You have an answer for that? All right. So one good example is that the formulation of Coca-Cola. So nobody else even now so knows the composition, chemical composition, and how it's being prepared. The syrup of Coca-Cola. We have manufacturing plants here in the Philippines, in Cagayan de Oro. That's a big manufacturing plant there. But of course, even those people working there, they don't know the exact formulation of Coca-Cola. They know how to produce it into a bottle, but then they don't have it. So what else? KFC fried chicken. So thank you, Julia. So the trade secret there, probably Julia might be referring to the preparation of the mix, the flour that covers the chicken. So it tastes differently. The mix, like what you're trying to buy now in the market, diba, na yung baligya. So what do you call that mix? The 7 herbs and spices. No, so you have that kind of special mix. No, so that is a trade secret for KFC. I think the other one is like, who else? Who among you can really replicate how Jollibee, like you can have a very crispy outside part of the chicken and yet very soft in the inside. So what preparation is that? You don't know exactly. I don't know exactly. I've tried that before, but to no avail. No, so you cannot replicate it. There's really a trade secret in terms of how they prepare chicken, and then when they cook it, because you can see how they cook, no? So in the Jollibee store, but you cannot replicate the taste of the like for example the skin, no, but very soft in the inside. So there's a trade secret to that. So there are companies who chose not to apply for IP protection. So okay, so these are the things that I've discussed, no? So in terms of patent and trade secret. Okay, so these are the patent certificates you'll get, no, if you applied for patent protection. So you still have time. Okay. So what is a patent? So a patent is an exclusive right granted for invention in exchange for the disclosure of the invention. In other words, a patent is an exclusive right to a product or a process that offers a new technical solution to a problem. That's how the World Intellectual Property Organization defines it. No? That is an exclusive right. So provided to the invention in exchange for the full disclosure of the invention. Okay, so there's also conditions there, right? So a patent is also a right to exclude others from making, selling, using, importing, offering for sale the claimed invention for a period of 20 years. So that's how long the invention can be protected. No? So nobody else should be operating in the market having the same invention as you have already made. No? So meaning to say you control the market now. No? So if you have an invention, so it's safe to say, if you have a granted patent, it's safe to say that you're the only person who would be able to sell the product in the Philippine market. Now, there's an exclusivity, there's a territorial nature here. So you have to apply for patent as well in other countries now. Otherwise, the protection will not, or those countries will not provide you with protection. So if you think that your product would be used in other Asian market, like in Singapore, Malaysia, Thailand, Indonesia, so you have to apply for patent protection. But this can be made easier through the PCT, the Patent Cooperation Treaty. You apply this PCT to WIPO, and then they will grant you international, it's not an international patent, but will allow you to easier access those other markets, like I mentioned the countries. So let us remember that you'll be enjoying 20 years by that time. So it's good for you if your innovation, there will be no other innovation for that particular period. But you know for a fact that technologies keep evolving. Like for example, in smartphones, every year Apple and Samsung, right, like really produce a products year in and year out, right? So that's what happens there. Okay, so now the condition is for us to disclose everything in detail about the invention. So the patent office will require us about that. So just like for example here, ngunani gyud ang patent document. So you have to identify what were the materials produced there, included there to produce this kind of a hamburger. So you have your top bun, your bottom bun. So you have your tomatoes, cheese, beef, pickles, lettuce, beef. What else? So every materials or ingredients that are provided in the hamburger, you have to disclose them. And then if the patent office is satisfied, then that's the time that they will grant you a patent. But there is really these three primary requirements. So number one, the technical solution of a problem should have novelty or newness, meaning to say what sets apart from your product to the other products existing in the market. So unsa may bag-o sa imo, no? So if it's not new, then X, no? Now, the most difficult part also is that your product should have an inventive step and should be industrially applicable. All right? So these are three different things now that you will be able to really provide proper disclosures to the patent office for us or for you and me to be provided with a patent. And so again, this can be a product or process. Okay, so that's it. Now, so this is also related, no, to your startup. Now, if you have a startup and then your startup has a product or process, you need to identify what's really different from your startup. Now, among the startups out there. Okay, so that's the thing. No, so you have to identify this. So it's just similar. No, so if you have a product that is new and involves inventive step, then you may have like a unique proposition to the market. Yeah. Okay, so these are some of the definitions for what can be considered new, inventive, and industry applicable. So it says here that invention must be new compared to the state of the art on the filing date of the application. So what do you mean by state of the art? Meaning to say there are existing technologies, products, or services even available today. Now that's the state, no? The state of the technology, the state of the art. They call this state of the art, but what really means is that what is the state of the technology for this particular product that you are offering. So the patent office will compare your product against the existing products out there. Now, I mentioned inventive step. This is the, I think, difficult part, no, to pass because it should not be obvious to a person skilled in the art. It must represent a sufficient advancement in relation to the state of the art. So to satisfy this requirement. So I'll give you one particular example. You have a glass of water, and now you're thinking about the glass, like the problem. So imagine the mug was not yet invented, right? So you kind of think about the glass of you're holding. It's slippery, so you kind of propose that there should be a handle out there. No? So you created a handle of the glass, and it becomes like what you have now, a mug. No? So that means that, well, it's new because nobody has yet created a mug before. No? So let's assume that. But when it comes to inventive step, the attachment of a handle can be considered very obvious. So that means that it will not pass the inventive step requirement. Okay, imagine that. No, so you just have attached the handle. Now, if you kind of introduce something like you have a mug, no, and then you found a way for you guys. You found a way that because mugs are usually being used for coffee, no, hot coffee. And then you found a way that you keep that coffee hot, no? So you found a way. And then you introduce that. So that can be considered possible, no, for an inventive step, especially if the solution provided in terms of making or maintaining the hotness of the coffee is not obvious, no? So that means that there is some configuration, electronic configuration out there that makes it warm or hot, no? So at the same time. All right, so industrial applicabilities, this is the easier part, no? So to pass, usually this is not a problem. It's always been the novelty, the newness, and the inventive step. So if you have, if you can mass produce the product that you are proposing, then that will pass the industrial applicability. So the first patent in the Philippines is actually a process, no? So how to recover oils from oleaginous meats of nuts, beans, and seeds. So that is in 1948. But in other developed countries like in Europe and in Europe or in the US, so they've been doing this for how many years already? In late 1800s, they've been working on patents already, no? And remember, guys, that even Albert Einstein,
before really the genius himself. No? So he worked in a patent office before, no? I think in Switzerland. No? So he was working in a patent office. No? So si idol Albert Einstein. No? So that's where also I think it triggered the mind of Albert Einstein when he was in the patent office, and then later on he became really famous because of these theories that they introduced. But he was there in the patent office working before. No? So I think I will not just skip this because these are the products that develop electronic products developed over the years, like the ATM machine, and it's really disrupted how we transact or get money from the banks. No? So these are pretty cool products that we have in the market today. The ATM card, the credit card, these are electronic products that we invented. Some also goes for Apple products that we have in the market right now. So these are some of the examples. Like for example, Apple here, there are around 27,000 you can find items that you can find in the European Patent Office alone for Apple. So that's the number of patents that they have. So these big companies really recognize the importance of patents, protecting the intellectual property. And you see this, you have iPads or the AirPods right now. This is some kind of the patent filings that you can find in the patent office. No? So how they were able to, so Apple disclosed this. No? So how they are being encased and being charged. Look at that. No? So in the figure in the left. So this figure here talks about how the battery is connected to this case, the communication interface, the processor, and the memory. So you think about that, and then the AirPod itself. So the wireless device, the microcontroller, the speaker, or the microphone. So how they actually being configured. So this one. So these companies really value patent protection, and we should also do the same. So for a particular car, so there are so many patents in this Toyota Prius car. There are over 24,000 patents already, in Prius. Yeah, so this is very, very cool product because not just patents, but what it does into the environment. So for 5G technology, so we have telecommunications technology right now that is beyond what we are used before. So 5G. And in terms of the competition, you have, of course, I'm not sure if you expected this, but Huawei in China led all the companies in terms of patent filings. But in terms of granted patents, you have Samsung as the leading company. Granted, that means you have a granted patents. So Samsung, and then what happens to well, we're not seeing here Apple, but you can see here ZTE, LG, Nokia. So these are companies that are into the patent race in terms of 5G. So again, they are very particular with patent. And today, for several years already, China is the highest number of patent applications. So that speaks in itself that China is really no longer about a manufacturing facility, but they're also right now the innovators. So the innovators leading in terms of patent application. So you cannot find the Philippines here, unfortunately. So maybe in the bottom, if there's a bottom to this list, because we're not even engaged in 5G. So even in terms of patent application, we'll be in the bottom. All right. So, but one doesn't need to be a rocket scientist to have a patent. Why? I'll show you some of the examples that have been granted patent, because we talk about like the devices, components by those electronic companies. How many of you have used this rotating map? Do you have this at home? This is a rotating map. Do you have this at home? Is this an invention? Is this a technical solution to a problem? I think the bigger question is, are you still there? All right, na sir. Thank you, Earl. Okay, so si Earl lang ang naay rotating map sa ilang balay. So siguro si Earl. Earl, do you also clean the house? Earl?
Yes, sir.
Okay, so you consider this an invention, Earl? All right, I think Earl muted this microphone already. So we have this rotating map, and the guys from China, the inventors, Zhu Yao Chen. Yeah. So no, so he's the guy who invented this, a Chinese guy, and then applied for patent in the U.S. and any other countries who can use this product. And actually, he licensed it now. No, so very cool inventions, very useful. So utility, industrial application is okay. Inventive, yes. No, so who can think about this? So nobody thought about this before this product was launched. So that's one of the requirements of inventive. So it might be like something new to you. So this is novel at the same time. So nobody even like make use of this. So this is the original product, guys. No, so ayaw lang tanawan ninyo ning gunit sa map. But then if you look at the the map here, so how you use it, no? So in the bottom, so that's how this product is innovative. So sige kong palitan eh kay mura bitaw kada kwarto o CR. So tulo among CR. So we have to buy each CR, no? So that's how you use it. So very cool. You don't have to touch it, no? Kaning map. Kanisa, no? You don't have to touch it. Like kung hugaw kayo siya, dili gini mo na sa gunitan, no? Kan rotate agad siya dira to clean, no? So it's easy, really easy. So unique selling proposition, very easy to use, no? So yeah, so primarily it's user friendly, no? So user friendly. So it comes with a lot of benefits. That's why this product is selling, no? This is a simple solution to a problem, right? So problema nimo is magsigi ka og kanang saan mo na, no? Imo nang i-grip, no, para makakuha ka hugaw, no? So you don't have to use your hands anymore. Right? Oh, so sorry kaya ni. Yeah, so I just tried to skip this. So problema, no? So I know there is some like maybe problems with controlling parts, no? So somebody thought about, why not introduce a patented deodorizing pad? No, indeed, this is an approved patent in the US. So the technology is yun sa inyo paggamit. So activated charcoal pad absorbs and filters the air. So this is something that people did, no, to solve that particular problem. Now, what do you do to determine that your invention is new or novel? So kind of conduct a patent search, explore, even Google. No, Google patents, use Google patents. So you can use that to find if the product that you're trying to develop is existing already or not. Okay, so that's an example. So it's no longer needed, and that's why when you sa EC, you propose a project, tapos it's already existing, we always decline it. No? So we always ask them, what is novel about this? What is inventive? How is this different from existing products? So you have to find similar technologies through patent search in the kind of patent search. So actually, we teach also how to conduct a patent search. So if you satisfy all patentability requirements, then it's okay. No? So if you pass that, so you'll be confident enough to say, yep, that is inventive. I should get a patent about with my product. No? And if not, so what happens if you only pass novelty and industrial application, and then you have a product that's also of use? So you don't pass the inventive step requirement. So you have an option to downgrade it as a utility model. And in the Australia, that is innovation patents. That's how we pronounce it, patents. In the US, petty patents. No? So that's how they categorize it. Okay. So a utility model is a kind of protection that is designed to protect innovations that are not sufficiently inventive to meet the inventive threshold required for standard patents application. So that's the thing, no? So you can have protection, but only utility model. But the protection is up to 7 years only, no, from the date of filing. So usually, between the two, patent and utility model, it's fast, very fast to get a UM. No? So it's less than 1 year, you can have your UM already. Or for patent, it will take you 5 years to really get a patent. No, that's the problem. Okay, so design gini siya ang utility model for the MSMEs. No? So if they are products, then they would apply for utility models. All right, so what can be patented? No, or in this regard, utility model. No? So sagging. No? So what's the problem here for sagging? So let's talk about banana. Now, in Japan, students or kids, elementary students, actually, they're required to really bring banana to school, no, as their snack. So healthy magod yan, no. So the problem is that if you put your banana immediately to your bag, that means that there's a risk na malata siya, no. So you know, mga bata, no. So somebody thought about, yeah, let's make a develop a banana holder or cover, no. So for this case, it's okay. So ang kalaan is it should follow the shape of the banana, no. But this is a firm plastic shape, no. So although the question is this invented? Yes. So there is a petty patent issued for this kind of design, no, or cover. So this is a petty patent. No? It's kind of easy to make, no. So yeah, so this is a invention. But then to address the problem of other shape and forms or size of banana, so somebody thought about making this one, right? So plastic nga pwede siya ma-elongate, so flexible, no? So pwede po siya ma-bend, no? So pwede po siya, no? So other solutions to other problems. All right, guys, let's proceed. All right, so you're seeing a drawing here. It says a finger-mounted insect dissuasion device and method of use. So, unsa may problem nga gina-solve ani? What do you think the problem is being solved in this kind of application? Is there actually a problem to this? Like, yeah, so you don't want your fingers to touch the kadiri na fly, nga na ba? No, so, well, somebody thought about this, and then they applied for petty patents, and indeed they were granted with the petty patents on this, no? But this is the question. Are all patents applied and approved have commercial success or commercial value? So have you seen this in the market? So these are type of the questions that we need to answer. So if we apply for a patent, we need to make sure that there will be people who will be really using our product. No? So I did not see this, no, in any department store. So wala, but I don't know, even Shopee and Lazada, if you can find this. But this is one crazy idea, no? But they got a patent for this. But commercial viability, that's a question. May pa ni siya, no? So napa ni siya. Okay. Yeah, that's correct. So mura siya useless, no? So don't file patent protection if it's gonna be useless, no? So there's no point of spending a lot of money. Do you know that's very expensive to file patent in the US? If for the motivation purposes only, na kay patent, then that's okay, no? But in terms of commercial, it's very expensive to maintain a patent. All right, so next is yeah, so this is granted with patent. This one, magamit kaya rin siya o dili? They call this as Berberella. Does it solve a problem? And what is the problem that is trying to solve with this product? Okay, ganahan ko ni Earl, kay murag kami giduhan ni Earl Mistorya, no? So maka-file ba og patent diri sa Pilipinas? Yes, we can file patent here, no? So we file a patent here, apply a patent here, then through the ITSO office now in the university, if you're still a student, you file a patent here, ITSO, our office will apply that to the IPOFIL. So there are, guys, there are so many students already, from AgEng, from AgEng ni CE na naka-file na og patent and utility model. Now, and I'm kind of like very happy because we will be granted a patent soon. And utility model is already approved na happy ka kay na yung mga estudyante niya na sila ikagalingon nilang patent or utility model. So we do that now for the students. So for this particular case, so of course this is an approved, no? What's the problem here? Kung bugnaw kayong beer, for the gentleman in here, the taste is really different kung ang beer is cold, right? So if you're in the beach, no, so sunny, imagine yourself na mo sa asa mo ron, sa Britannia, no, and then you're in the island and then you're enjoying your beer, no, cold beer. Ipagawas nimo nya sitting in the beach, no, so lying down, and then of course you don't want your beer nga dali mawala ang bugnaw, so you cover with this beer berela. No, so unique. This is a petty pattern because this is obvious, no? So you have a holder, so it's kind of address a problem, and then you kind of cover it with a umbrella. So they call this beer umbrella. So I don't know even, I'm not sure even if you can find this in the market today. This one, I think, pretty impressive cover for the shoes, no? So pag ulan. So you can install a umbrella again. Shoe berela siguro na, no? If we have a beer berela, this should be a shoe berela. No, shoe berela. And then you have a covering here. No? So it's a problem ani, no? So it's a problem aning ginasolve. Do you know? Ang problem ani in kaning product. What product is this? So do you know? Guys? What problem is this product trying to provide solution to? Okay, para sa hair, sir. That's right, Julia. Thank you. Anna also responded para sa buhok, no? So that's right. So, para ang buhok, dili makaon o gapil, no? So dili mahalo sa noodles. Inig kaon, no? So gidemonstrate na niya diri, gipakita lang niya, no? So usually pag siguro girls mukaon, inyo mo gid nang ikuan, no? Inyo mo gid nang i-wrap around sa likod, no? So pero kuan, if you have this, so safe bala na nasa front. So dili siya masagol sa pagkaon, no? Ang buhok. Alright, thank you guys for answering. Appreciate that. So do you have questions so far? Do you have questions? So please drop, no, sa chat box lang, like Earl mentioned. So I will skip the integrated circuits now because you're not ECE students. So far we've covered the intellectual property and then the types of intellectual property or IP, patent, and utility model. Now I'll introduce you to the industrial design. We have 20 minutes left. So industrial design is or refers to the ornamental or aesthetic aspects of a product. So that can be three-dimensional features as the shape of the product, or two-dimensional features as an ornamentation, patterns, lines, or colors of a product, and or a combination of one or more such features. So for example here, 3D and 2D, no? So three-dimensional, no? So this is design. So if you have the design already protected, applied for protection, so it doesn't solve a problem, no? It's just that you can use this to lie down, no? And then you have a head. I don't know if that's going to be considered as headboard, no? So it's like something that you can sit down and lie down. That is a 3D design. But for two-dimensional, so you can have these shapes, no? Or different shapes, different colors embedded in clothing. No, so that can be considered as a two-dimensional design. All right, so industrial designs. So you can apply for this. No? So now some more examples like the plastic bottles that we use for your cooking oil, for mineral water, no? So toothbrush. So if you go to a like Robinson's, no, in their supermarket, you cannot really find similar shapes of like the bottle of the mineral water or the cooking oil, you cannot find, because these companies also apply for industrial design. So they apply for industrial design, and they have the right, really the exclusive right to use that specific design. So nobody else cannot or can use that same design. So that's why you cannot find it out there. Even the Coca-Cola bottle, so we will always refer to, well, the body is like shaped the Coca-Cola, the 12 ounce, for example. So we refer to that. So that's why Pepsi does its own have their own design. Okay, and industrial design also includes mobile phones, right? So mentioned here. So three-dimensional designs, more or less. That's why you will also find in the car industry, you cannot find, I mean, the same design of the car. Like you have the Toyota Fortuner, very different design with the Mitsubishi Montero Sports, not to the Ford Everest. These are the SUVs, but they have different designs. So you cannot copy the design, even if the Toyota Fortuner or the Mitsubishi Montero have a very unique design. You cannot copy them. They are protected under industrial design. So Kenneth Cobonpe designed this chair. So it's very expensive chair here. So I'll tell you a story. So during I think the ASEAN summit, you find this chair, the red chair here. Kenneth Cobonpe designed this for the head of states. Even I think who was it? Barack Obama was here. They used this, the world leaders. So during that 2018 or 2017, so there was a summit here in the Philippines, and they used this. Kenneth Cobonpe used this very expensive chair. The price of this was around 75,000. So, and then there were some of the designers, local designers, that were also interested. They also produced like this. So even the locals, so they kind of produce this thing. So they copied the industrial design. So, but Kenneth Cobonpe applied for the industrial design that time, when he released this product to the ASEAN summit. And then when this was mass produced by other people, Kenneth Cobonpe was alarmed, because he was selling this for around 75,000. The buyers of this this is Angelina Jolie, So Angelina Jolie. So Angelina Jolie buy this for how many thousands of US dollars. And for this case here, this one here, so a lot of people were producing this and then selling it for 15K. So that's how much that the people are selling this. And then Cobonpe was alarmed. So what happened next was he called the attention of the DTI, the IPOFIL, and the NBI, and really sought help and went after to those stores who were selling this and to those companies who were really mass producing this. And then the NBI confiscated everything. And then they actually burned all of those confiscated. So that's how strong the IP system in the Philippines is. If you have a basis now that you have protection, then you can enforce it. So with the help of of course, the IPOFIL, the NBI. So that's what happened here. So when you copy a product, do you know, guys, that you can find this in the Watergate, in the swimming pool? Check for yourself. So you take a photo of it and then show it to me, get back to me. Yeah, you really can find this product there. Okay. Next. Okay, I think we're okay with this. Industrial design. How long the protection lasts? Yeah, you can have a total of 15 years if it's still worth renewing every 5 years. So remember, there's different kind of protection. So after that protection, nag-lapse na, then you can mass produce the product. So that means to say, kani siya, after 15 years, pwede na mo ni kopyahon, ibaligya na. That's the only time you can sell this kind of product. The question is, after 15 years, okay pa ba niya? Appealing pa ba niya? So if it is appealing still to the market, then feel free to copy it. So that's the IP system we have. Now, if over 15 years. Okay, I hope that's clear, no? So I hope I gave you a very good example. So in terms of protection. Now, we got to trademark. Now, so this is very familiar. Yeah, I think topic as well, no? Because well, you see this often in many business establishments. Now, let's try to define this. So trademark is actually a word, a group of words, sign, symbol, logo, or a combination thereof that identifies and differentiates the source of the goods or services of one entity from those of others. So if you have a trademark, that represents the company itself. No? So if you see a word there, a group of words there, a sign, a symbol, a logo of the company, you immediately associate that with the company. No? So Jollibee, what kind of design or logo that you can find immediately that you identify that is Jollibee? That there's a Jollibee store there. So, feel free to chat. No? So what's that? No? So unsa man say symbol? Like for McDonald's, what kind of logo or design you will find that you can say that's really the McDonald's? So naay buyog, Jaya Desiri, no, may mention about the B. That's correct. No, so thank you guys. Yeah, so if you're a business distinguishing your goods or services from others gives you a competitive edge. Learn more about trademarks, how to apply for protection, and how to manage them. So if you're already into the business, make sure that you develop a trademark. Sometimes they associate that is their brand, no? So they put a logo there, so that means that is your company, that like in the product itself, you stamp it. So yeah, so even in the food boxes of Jollibee, diba, you see the buyog, no? Then the word Jollibee. So you have a symbol there, a logo there, and then the words Jollibee. So that is trademark. Okay. So some of the trademarks that you can find out there, popular trademarks, right? So these are the trademarks that are being used by the companies. I'm sorry, no, we don't have much time. I'll try to expedite this. I have plenty of examples, but we are really limited with the 1.5 hours. So for a trademark, that can be protected in perpetuity for as long as the company is there. No? So that's why the Jollibee trademark, unlike the patent na 20 years lang, utility model 7 years lang, industrial designs 15 years lang, and trademark can be, as long as the company exists, they can be protected, no, and trademark, your logo, your design, the words. So there should be no other. So kung magtukod kag Jollibee karon, magtukod ka og kanang chicken restaurant, unya gamiton niyo ang Jollibee nga word, you will not be allowed to use that, no? Because there is a trademark protection for that. Even the buyog itself, you cannot use that, no? So the period of protection is 10 years from the date of issuance and is renewable for 10 years at a time. So forever. So there is such thing as forever, no, in IP. That's called trademark. Kung walang forever sa patent, sa trademark meron, no, forever yan. Okay? Forever pa sa love ninyo sa. Okay. So well, if you find the logo na R and TM, so what's the difference, no? So here, if the TM symbol can generally be used by any person or business to indicate that the particular word, phrase, or logo is intended to serve as an identifier for the source of the product or service. It's not yet registered, no? It's not yet properly registered, no? So they would want to use it in advance, the TM, no, to symbolize na they're intending really to apply for trademark. Okay, we have a question here, no, from Gia. What if kanang nag-franchise sa Jollibee, appeal na sila sa protection? So, yes, no? So I think sa mga Jollibee diri sa Butuan is franchise na, no? Kanang na diri sa kanto sa Montilla, that's a franchise. But for Jollibee, kaning mga bag-o nga Jollibee stores, Jollibee said it's no longer a franchise, but still they're protected, no? So if you are a franchise, okay? So, but if you're not a franchisee, then there can be a problem with that. Take it here. The R symbol indicates that this word, phrase, or logo is already a registered trademark for the product or service. So, registered already, no? So it's difficult to use that because that is already registered. Okay, so I hope this is clear, no, the difference between the two. Ang isa is in napala intention, no, they're also actually in the process, no, of applying TM. So trademark parody, you see a lot of parody, making fun of the trademarks, and as long as the companies are not affected, their businesses are not affected, they will not like go after these people. Like you just wear it on your shirts. Well, I don't think that the North Face, Coca-Cola will go after you, no, because well, you're not making money out of it, no. So can you put siya, no? So this is very funny because people started to combine McDonald's. All right. Question here for you guys. Answer me with yes or no on the chat box. Everybody, please. Will you commit a violation or infringement in using this McDolby? Yes or no? Will you commit infringement? Okay, I see one answer. There are 32 of you here. Yes. How about the other guys? Will you commit infringement? Mary, yes. Lovin, yes. Okay. Grace, yes. Danica, yes. Donna, yes. Mary's Angel, yes. Glad Care, yes. Julia, no, sir. Yes. All right. Very interesting answer from Julia. Why do you think, Julia, you will not commit violation and infringement? Because most of your classmates here, yeah, they answered yes. What's the reason? What's the logic behind? Okay, kay naman ng tumbi o face cloud. Okay. So, would you like to share your comments? Combined, sir. All right. So, would you like to share your thoughts, Julia? So, doubt mic, sir. Doubt the mic ni Julia, no? So, safe. You're safe. So, i-type na lang yung answer. Why do you think it's not? Same sa kadtong 7-Eleven, sir. Oh, Grace, you kind of like touch on this. I've heard that in the Butuan City. That's true. No, 7-Eleven, nahimo siyang, that's really funny, guys. Nahimo siyang 7-Evelyn. Evelyn ba to? Or so 7-Evelyn. Yeah, that's true, no? So it's kind of part of the parody, no? And I'm not sure if Jollibee and McDonald's were really after them. It's like right now, if you see this, how many are they? No, so there are only 4 of this. So it's like a franchise already, no? Because they're using the McDolibee. And then you see it's very funny because McDonald's and the Jollibee logo here, parang amigo kayo, no? So this is kind of parody, but yeah, so if Jollibee will really and McDo will really go after this because it sounds like they copied it, or it looks like they copied it. So the color and yeah, the drawings. So they'll get in trouble, no? They'll get in trouble. But I don't think that Jollibee is very serious, no? So I think katong sa 7. Earl, can you expound on this, Earl? What happened there? Sa 7-Evelyn? What happened to 7-Evelyn? Gipatanggal. Yes, that's correct. No, gipatanggal. Gipatanggal immediately kay pareho daw. No, so 7-Evelyn. So sounds like bagyod. No, so sounds like 7-Evelyn. Actually, there can be no. So ang problem there is that the drawing, the color scheme, no, the color scheme. If you look at the trademark database that you can find in IPOPHIL, the Intellectual Property Office of the Philippines, no, ang kanang color green, ang color scheme ba? So they're also protected actually, no. So ang color like kaning red sa Jollibee. So apply mo kag trademark, imo gina siyang discuss, no, ang not only the design but also the color scheme, no. So imo mo gina siyang i-discuss yun, no, so when you apply for the trademark. So you want to say discuss. No? So for the 7-Eleven case, no, so more, more or less it sounds like the 7-Eleven, but the color scheme dito maupod to yun isa, no? But if you design a different color scheme and then you say 7-Eleven, that could be difficult, no? Kay there's a parang legal na definitions on what not what to ano, no. Yeah, of course, kung ang katupong figure, I do not have the logo. I hope you can share that with me, no. Kanang number pud nga 7 kung gi-follow gyud exactly sa 7-Eleven. Kay na 7-Eleven, no, 7 nga figure niya 11. And then ikaw pud ang 7-Eleven, 7 pud nga figure niya 11 pud pareho gyud, so that will not be accepted. But if you have a store nga dili sa figure, no, word sa 7-Eleven, maglisod gyud ang kuha nato, no, o pa-take down ang 7-Eleven nga store. No, maglisod sila take down because the word is different now from the figure, no? So ingon na siya. So there will be like the two sides will argue with one another, you know. So that's why na arbitration sa IPO, no? So you go there and then settle the case. All right? So specific examples daghan. So the difference between trademarks and industrial design is that the trademarks are signs that distinguish the goods or services of a company, where as the industrial design protects the whole or partial appearance of goods. So I hope you can remember these things. All right, so these are our references. So we have different references, and it's already 12 o'clock. We're right on time. So I hope to cover also copyright, but then we don't have much time. So I want you guys to, for me, no. So I have actually na ako'y kuano kanang YouTube video about discussing more about intellectual property. Let me see the link here, if I can share that, so that the details about the intellectual property. No? So, wait lang ha. I'll try to access my YouTube channel. No, that's where I actually, guys, that's where I put my classes, no, sa sa Technopreneurship 101. I have my YouTube channel. You can find my YouTube channel. Right. So I'm gonna share you about intellectual property na link. No? So I'll give you more details about the other forms of IP. But what I discussed to you are the most important part, no, of the intellectual property, because as engineers we always refer to patents. We always discuss about that. So let me, okay, I found it. So the link. So please, if you have time, guys, I want you to watch a portion of this that we have not covered. There's some other things that we might want to discuss. No? All right, so I'll post it in the chat box. If you have time, please visit my YouTube site. No? So if you want also lectures about Technopreneurship 101, I also posted my videos there in the playlist. No? So you can actually find lectures about, for example, in terms of the Tech 101. All right. So I think we've covered. It's already 12 o'clock, no? So I think we've covered a lot of things. So basic things that I want to have. All right. So yeah, is it possible, because we're closing now, I would like to thank you guys for joining the very short webinar we have. I think I hope that you have learned something new and different today. So daghang salamat sa tanan. Would you be able to turn on your video for a screenshot so that I can submit this to your professors as well? Would you be able to do that, to turn on your video? Kung okay lang sa inyo. No, so for a very short time, if you can open your video so I can screenshot and then message your professors as well. No? All right. Right, I'm seeing yeah, guys. So thank you. No, I hope you learned something new today. So I'll take a screenshot in 5, 4. Maybe you can smile. 5, 4, 3, 2, 1. Smile, everybody. All right. All right. Thank you, guys, and have a wonderful day. Salamat sa tanan. Bye-bye. Thank you.
Thank you, sir.
Salamat po.
Thank you, sir.
Okay, you're welcome. All right. Bye-bye. Okay. Keep safe, guys. COVID is a lot of cases are here. Bye-bye. You're welcome, everyone.